English schemes of arrangement have become a popular and highly effective tool in cross-border corporate restructurings. They offer companies the ability to agree restructuring terms with their larger groups of creditors and then impose those terms on a dissenting minority outside of a formal insolvency process. Importantly, schemes are open to and often utilised by foreign companies provided certain tests can be satisfied. One question we are now hearing regularly for obvious reasons is whether English schemes of arrangement will continue to be a viable tool even after Brexit. Before they're willing to sanction a scheme, English courts are keen to ensure that the scheme will be effective in and enforced and recognised in the relevant overseas jurisdictions. When it comes to schemes being used for European companies or companies with operations and assets in Europe, the English courts have commonly looked to several different European regulations, most notably the Recast Judgments Reg, as one potential pillar for recognition. It's worth noting, as an aside, that recognition and enforceability of schemes is not governed by the EU insolvency regulation, as schemes are not listed as insolvency proceedings, and so that regulation ceasing to have effect would not have an impact on the recognition of schemes. Nevertheless, if there is no Brexit deal, if those regulations fall away and no reciprocal arrangements are put in place for recognition of judgments and proceedings, then this particular pillar for recognition of schemes will fall away as well. However, this is not the death knell for schemes. Many schemes have been implemented by non-EU companies, and scheme processes in other countries, such as Cayman and Bermuda, have regularly been given effect with no need to use EU legislation. Instead, the English court will need to see alternative evidence for international recognition, most likely through some combination of international treaties, international common law or comity, and through the general principle upheld in almost every legal regime that sophisticated parties are entitled to elect the governing law of their arrangements and make themselves subject to legal mechanisms provided for under that law, such as schemes under English law. Nevertheless, it is probably fair to assume that scheme recognition analysis may become more complex as a result of Brexit, certainly for the initial few months after Brexit takes effect. And as a result, we expect there to be a greater focus on the expert evidence adduced to the court to support recognition. Overall, we expect schemes to continue to be prevalent in major international restructurings, even after Brexit. The UK has a long track record of restructurings, and the dominance of English governing law, combined with the strength of the English judiciary, means we still expect schemes to be the go-to option, at least in the near term. But realistically, only time will tell how much of an impact Brexit, as well as the rise in other international processes such as the new Dutch and German restructuring regimes, will dilute schemes' current dominant position in that market.